That'll confuse everyone. So, all right, Chapter 7, Case Management. As it says in 7.1, the court has always been understood to have the power to manage its affairs effectively. Obviously, there was a significant shift of mindset in 2007 with the advent of the civil rules, and the court then playing a much more active role as a case manager. And as it says, up until then, it had perhaps been more of an umpire, not actively interfering, but leaving it to the parties to largely influence the kind of timetable for proceedings. As an example of that, it says in my first footnote of this chapter, prior to 2007, there was no power to use a notice to admit facts here, which meant the system for pretrial admissions was effectively voluntary and led to the, I feel, deeply felt comment by Dawes in his 2003 work that there was a particular problem when dealing with certain opponents, not named for obvious reasons, but who had or exhibited an obstinate refusal to admit facts that he clearly felt it was in everybody's interest that they just admitted. So to that extent, I suppose what we could draw from that is a thought that before 2007, maybe Guernsey advocates were kind of more games playing than they are these days, where, you know, you've got the obligation under Rule 1, not just for the court to pursue the overriding objective, but for the advocates to facilitate that and always have that in mind as well. So there's a, if you like, there's a higher ideal rather than simply being partisan all the time and taking every little point. All right, so yes. Yes. Well, I don't know. Isn't there no procedure for that? Well, I'll carry on talking. You can have a look. We'll never find anything. No, well, the question is how do you do it? Yeah, but in terms of a rule, I don't know. I can't. I mean, I haven't cited a rule there, so I would have thought if I could have found one, I would have thrown it in there. But yeah. All right. Well, okay. I'm going to throw my hat into the ring here and say Rule 50. Rule 50, Rule 51, general powers of the court and court's power to make an order of its own initiative. Yeah. Yeah. Okay. Right. All right. Well, we can also see there in 7.2 the reference to Rule 38, court's obligation to actively manage cases. So to encourage cooperation, which again doesn't seem to be reflected in the Dawes quote there about dealing with certain opponents. Don't seem to be terribly cooperative there. Identifying the issues at an early stage, deciding promptly which issues need full investigation and trial and which others can be disposed of summarily without the need for a hearing, working out the order in which any remaining issues will be examined and determined, to encourage ADR and facilitate the parties using it by granting adjournments so that they can go off and explore those possibilities. Encouraging settlement of as many issues as they can, setting time limits, generally controlling case progress, and then giving directions for an effective and swift trial if indeed there has to be one. Cool. So as it says, a number of tools given to the court to achieve all these ends, and probably the most significant single one is the Case Management Conference. So as it says there under Rule 39, within 14 days of inscription, the plaintiff shall apply for the court to set a date for a case management conference to take place. But as it says, the court doesn't have to wait. So within that 14-day period, the court can set a date where the parties have agreed and made an application to that effect. But also under Rule 39, and this is clearly active case management, the court can fix a date for case management conference of its own volition, even where the parties aren't on agreement, in agreement with that, if that step is considered to be expedient. Yes, all right. So where the plaintiff does apply in the traditional fashion for the court to set a date for the case management conference, he files 2 copies of his application. He also files 2 sets of the pleadings. And when the court hears the application, the judge allocated should be the one who has overall and continuing responsibility for the case. And as my footnote says there, if there's going to be any point that you can see taking on recusal of the judge, Mr. Kirk, is he still around? Mr. Kirk? Yes. Because he likes to have everybody recused, doesn't he? But yeah, right. So unless he's one of the litigants, then maybe recusal would not be a foreseeable issue. But all right. So yes, court at the CMC hearing, the court will consider ADR. So pushing that further. What else do we need to think about? Yes. So where the parties have been able to agree most of the directions for the future conduct of the case, the court may actually decide that it doesn't need to have a case management conference. So in certain circumstances, can dispense with that, which I think is picked up in 7.7. So yeah, dispensing with case management conference, so again under Rule 38. Can only do that where it's satisfied either it doesn't need a case management conference to deal with the case justly, or the cost benefit analysis that would be done pursuant to Rule 38(2)H shows that a case management conference should not take place, or it's urgent, the case is an urgent one, and we just need to crack on without having a CMC. Now, as it says in 7.7, under the 2008 Practice Direction 3, it was thought that once these rules, obviously 2008 was just the year after the civil rules came in 2007. So the practice direction suggests that once those rules have been in operation for a period of time, it may be possible for counsel to agree directions for future case management without requiring a CMC. But until that time arises, it is thought that every case should have a CMC, in particular where there's a litigant in person or the issues aren't straightforward. Now, I defer to you guys. Have we reached that point where not every case has to have a CMC? Yeah? Yeah. So people are just agreeing stuff. Yeah. Yeah. All right. Good. Interesting. All right. So. They don't have the same procedure. No. Yes, this listing questionnaire. Yeah. Oh, for the case management. Yeah. Right. Yeah. Yeah. No. It's not the court. Okay. All right. Yes. All right. So going back to 7.5, things that could happen or should happen, as it says, the court must. That's what Rule 41 says. Court must at the CMC give directions on disclosure, how that's going to happen, evidence, maybe the forms that the evidence is going to take, maybe how much evidence, maybe I don't know, limitation on number of expert witnesses, that type of thing. Direct whether it's judge alone or judge with jurats. Fix a date for a pre-trial review unless it's thought that that isn't necessary. Fix the trial date and fix the date for the listing questionnaire to be lodged with the GREF unless it decides to do away with that. The listing questionnaire is picked up at 7.9 and onwards. Again, in advance of the case management conference, parties are encouraged to agree the directions as much as possible, present them to the court, and if they can't agree, they should set out what they want the court to do. Again, the case management conference can be adjourned with a view to encouraging ADR, but as it says in 7.6, whenever a CMC is adjourned, the court is to fix the date, time and place for its resumption. There has to be a definite point when everybody's going to come back to court. So drift is not to be encouraged. And when it does come back, it should come back to the same judge whenever possible. Obviously, I guess, I don't know, in this jurisdiction, it's a bit hard because judges kind of come and go a little bit. No, don't come and go. No, okay. Right. Okay. When have like commissioners? Well, no. Okay. All right. Okay. So, all right. So you'll have a kind of more or less permanent judicial body. So it should be relatively straightforward to then make sure, although of course only a small judicial body, but make sure it's coming back before a lieutenant bailiff, possibly. Do you have lieutenant bailiffs or is it lieutenant bailiffs? Just thought I'd check. Right, okay, so we've done that. All right, listing questionnaire then. As it says, generally everybody has to file a completed listing questionnaire with the court by the date fixed. That's normally fixed at the CMC. Failing to meet that deadline can result in a listing appointment. So it's like a kind of, come and see the headmaster. So yeah, can use a listing appointment where it thinks necessary to help decide future directions as well. Once it has held a listing appointment or everybody has done their homework properly and filed a satisfactorily completed listing questionnaire, or the court has decided to do without it, the trial date or trial period is fixed. At least 8 weeks notice, unless everybody agrees you can go to shorter notice. And then there'll be a date usually set for pre-trial review, unless that's been dispensed with as well. And certainly the trend here seems to be to always be thinking, is it necessary or can we get rid of it? So should be a pre-trial memorandum filed, and that should set out concise statement of the nature of the proceedings, any admissions that parties have already made, the contentions, both in fact and law, and a statement of the issues that the trial still has to determine, and that's Rule 47. The court will then give further directions for conduct of the trial, so for fairly obvious standard reasons, and the court will ask the parties to produce a core bundle of documents. This will be documents that the court either needs to review, possibly because they will be their content will be disputed, or in any event, ones to which repeated reference will be made at the trial. And you could also have agreed statements of fact. It says there, basic scientific, technical, or medical matters that are an issue, and any relevant specialist area of law. So that's that. I think really summary procedure, mustn't forget that. Under Rule 49, the court can decide to do without a CMC or, bless you, or a pre-trial review. Can dispense with any requirements about bundles at all. So as it says at the end there, court can give whatever directions it considers are likely to assist the court in holding a speedy and just trial of the action. So all of those things can be swept aside if the circumstances are right. So there we are. Let me see. Right, good. So are we stopping now?